What I have for you today is a case that is not about international tax, and yes, yet it is about international tax. It is a case about treaty interpretation, and more specifically about common interpretation in treaties. And it is the base case that is referred to in all the tax cases where they say, if you have a common interpretation, you need to do it as was done in Fothergill versus Monarch Airlines. And as you can see, Monarch Airlines was a low-cost aircraft carrier until in the early 2020s when it went bankrupt, but it existed way back in the 80s already, and the cases are going between them and one of their passengers, Mr. Fothergill. Now, apart from Mr. Fothergill's name, I love the name of the judges in this case. It's a decision from the House of Lords in England, and as you can see, the names of the Lords are Wilberforce, Diplock, Fraser of Tullybelton, Scarman, and Roskill. I think it is really some wonderful names. So what's gone on here? Lord Wilberforce summarizes the facts for us, and he says, this appeal involves a small sum of money, L1650. I have no idea what that is, whether that's pounds or whether that is the currency in which you claim for damages. But he's set to raise two questions of general importance. He does, in addition, raise the required discussion of some important issues concerned with the interpretation of treaties, and that's what we're after, right? So the facts: the respondent, Mr. Fothergill, in March 1975, arrived at Luton Airport, and he came from Rome, so it was after an international flight on one of the applicant's aircrafts, and that is the Monarch Airlines here. When his registered baggage, consisting of a suitcase containing personal effects, was delivered to him, he noticed that it was damaged. He immediately reported this to an official of the airline, and, as apparently usual, a property irregularity report, a PIR, on a printed form was completed, saying that the baggage was damaged. Under the heading Nature of Damage, there was inserted, side seam completely parted from the case. The damage incurred on inbound flight. This damage was later fixed at L1250, and in due course the airline accepted the liability for it. So the suitcase was about worth L1250, and then whatever the real claim was 1650, right? And here we see, after Mr. Fothergill reached home, he discovered that some of the contents were missing: a shirt, a pair of sandals, and a cardigan, value L1650, and that is what we're arguing about here. Mr. Fothergill recovered the sum from his insurers, who now support his claim against the airline. And what's going on here is, this is a ridiculous small amount, but as you can imagine, this kind of loss of goods happen all the time, and then you turn to your insurance company, and your insurance company turns to the airline, and the airline turns to their insurance company, and all of a sudden you've got two very big insurance companies with thousands of cases dealing with this kind of thing, saying, do we need to pay, who needs to pay? And that is what this case really is about. So it's actually about quite a lot of money, a lot of principles, even though the basic cases look pretty simple. So let's see what they say. The flight in question was international carriage and was governed by the Warsaw Convention of 1929 as amended by the Hague Protocol of 1955. And this deals with international airline transportation, right? The airline relies on Article 26 as an answer to the claim, basically saying we don't need to pay, and this is what the Article 26 says. A receipt by the person entitled to delivery of baggage or cargo without complaint is prima facie evidence that the same has been delivered in good condition and in accordance with the documents of carriage. In the case of damage, the person entitled to delivery must complain to the carrier forthwith after the discovery of the damage, and at the latest within 7 days from the receipt in the case of baggage, and 14 days from the date of receipt in the case of cargo. Failing, paragraph 4, complaint within the times aforesaid, no action shall lie against the carrier, save in the case of fraud on his part. So apparently Mr. Fothergill complained about the missing items later than 7 days after he got his baggage. And the case then goes on to say the airline claims that Mr. Fothergill should have complained of the loss within 7 days, and that since he did not do so, his claim is barred by paragraph 4. Mr. Fothergill's answer to this is first that no complaint was necessary, since paragraph 2 applies only to damage and not to loss, total or partial, and second that if a complaint was necessary, he made one in time through the PIR. So if you look at paragraph 2 of Article 26, it says in the case of damage, right? And Fothergill says, I don't have damage, I just have loss. That's not damage. And the case really is about how do you interpret the word damage? Does it include loss? Yes or no? And then this is a treaty, so how do you interpret that treaty, and how do you make sure that you have a common interpretation of the treaty? Now, spoiler alert, Fothergill lost this case because basically they said that damage does include a loss and partial loss, and what he computed on the form when he filed it simply talked about the zipper being separated from the suitcase. It said nothing about shirts and about cardigans and about sandals, so therefore he did not file on time. But it is the way that the judges get there that counts, right? So the judge starts with the purpose and intent of the treaty, very much following the Vienna Convention on the Law of Treaties, and they refer to this several times. And he says, the purpose of Article 26 appears to me to be reasonably clear. It is 1, to enable the airline to check the nature of the damage. 2, to enable it to make inquiries how and when it occurred. 3, to enable it to assess its possible liability, to make provisions in its accounts and, if necessary, to claim on its insurance. And 4, to enable it to ensure that the relevant documents are retained until the issue of liability is disposed of. If one then inquires whether these considerations are relevant to a case of partial loss of objects contained in the baggage, the answer cannot be doubtful. They clearly are. Moreover, prompt notification may give the airline an opportunity to recovering the objects lost, right? So this is what the judge says, and he says in particular as regard 4, preservation of the baggage check is important, and then he goes on. And he says, there seems on the contrary to be no sense in making a distinction between damage to baggage, which presumably must include damage to contents, and loss of contents. What then of the language? No doubt in an English legal context, loss is one thing, damage another. But the nature of the text in question does not suggest that it was drafted with strict English meanings in mind. And then we come back to this question, so is damage, does it include partial loss, yes or no? And then we get to common interpretation, because the judge says, I should add that we were referred to a number of decided cases in various foreign courts, only a few of which are cited below. But with all recognition to the diligence of counsel, I do not think that I need to summarize them for three reasons. And this is important because the judge basically says why we shouldn't always look at foreign case decisions, right? He says, first, with the exception of one decision of the Belgian Cour de Cassation, they are not decisions of highest courts. And the judge's point here is, if it's not the highest court that decided it, whatever decision you look at might get overruled still, right? Secondly, the process of law reporting varies from country to country, and they may not all be exhaustive. And what the judge says here is, you might find one case in another country supporting your argument, but there might be 3 other cases in that same country which do not support your argument, but simply have not been published. And then you would have kind of a false evidence that other countries agree with you. And he says, thirdly, it was not beyond argument when the facts of each case were carefully examined on which side the preponderance in quantity or quality lay. It is safe to say that your lordship's decision in this case will not be out of line with the balance of decisions given elsewhere. In other words, the decisions didn't come to one definite, clear answer, is what he's saying. And he goes on and he says, there's little firm authority in English law supporting the use of Travaux preparatoires, so the documents that you make in order to make the final treaty, in the interpretation of treaties or conventions. When dealing with an international treaty, or convention, I think there is no doubt that international courts and tribunals do in general make use of travaux preparatoires as an aid to interpretation. This practice is cautiously endorsed by Article 32 of the Vienna Convention on the Law of Treaties. In the interest of uniformity of application, we ought, in considering whether to use travaux preparatoires, to have regard to the general practice applied or likely to be applied in the courts of other countries, other contracting states. So what he says here is if other countries look at travaux preparatoires, then we probably should do the same as well, so we get to a uniform interpretation. But there are a number of buts. And he says a second important illustration of that you need to be careful is provided by a decision from 1977. Remember, this case is from 1980 of the French Cour de Cassation sitting in the Assemblée Plénière in a case where on the Warsaw Convention, so the same treaty, Article 29, it was Laurence was France, and the Advocate General here said, I shall not take up time on the old dispute concerning the general scope of travaux preparatoires. I shall limit myself to the observation that when one is concerned with travaux preparatoires for an international convention, there may be special reasons for not placing too much reliance on them. The first is that although for a French lawyer, these travaux preparatoires may be of some value, at least by way of guidance, they have none for a lawyer brought up on the principles of Anglo-Saxon law. And what he says here is, when you look at treaties, we can't just apply French practice. We need to think of treaties international, and if the Brits don't pay too much attention to the travaux preparatoires, then maybe we should not either, right? And then the British judge goes on and say, we need to meet these guys halfway. So he says, my lords, if one accepts that this reflects a recognition on the part of French law that in the interest of uniformity with English tendencies, perhaps rather overstated by the Advocate General because he says they don't pay any attention to travaux preparatoires. The English judge says the use of travaux preparatoires in the interpretation of treaties should be cautious. I think that it would be proper for us in the same interest to recognize that there may be cases where such travaux preparatoires can profitably be used. So what the English judge says is let's meet them halfway. They don't give full attention to travaux preparatoires, but we don't give no attention whatsoever either, right? And that is a part of a common interpretation. In my opinion, therefore, the judge concludes the appeal must be allowed, which means that Monarch Airlines win and Mr. Fothergill does not get his money back for his shirt and his cardigan and his sandals because he didn't file that report within 7 days. Now let's have a look and see what other judges say about this. You have the judgment from Lord Fraser of Tullybilton, and he's very short, but what I quote here is very short. It says, with regards to the question of whether there was an agreement at the Hague Conference on the construction of the word damage in Article 26.2, the minutes show that there was discussion in which some delegations expressed the view that damage clearly included partial loss, and others, including the British, expressed the opposite view. At a meeting on the 27th of September 1955, the delegate from the Netherlands proposed, seconded by a Swedish delegate, the addition of the words or partial loss after the word damage. The minutes record that eventually they withdrew their proposal on the understanding that the word damage was to be understood as including the words partial loss. But the minutes do not show that that understanding was generally accepted, or that it was given official recognition by the President. And what is happening here is so important, right? Because you may very often speak to people who say, well, when we were at the OECD, it was decided that this is how the text needs to be interpreted, or this is what these words meant, or the same for a treaty. And one has to realize that statement is anecdotal, right? If that statement isn't in writing, and if it is not generally accepted by everyone, I mean, here you have the minutes saying that they proposed something and that they withdrew it because it was understood that it was including partial loss, but nowhere did everyone agree that it was partial loss. So you cannot say that there was partial loss, right? And I like what the point that the judge makes here, saying, we got to be careful with half-baked evidence or anecdotal evidence when coming to interpreting documents and looking at the travaux preparatoires. Even if the French may use it, we should also do so, but we should do it carefully. And then the next judge, Lord Scarman, says, I venture, however, to add some comments of my own as to the correct approach by our courts to the interpretation of the international conventions. And the reason why he says this is, you've already said I agree with the others, Monarch win, but he says I want to make my own comments, right? The case concerns the Warsaw Convention on unification of certain rules relating to international carriage by air, and this is important. It's a convention on the unification of certain rules, right? I would construe it as meaning physical. I would construe damage as meaning physical injury to baggage or cargo, and as excluding partial loss of the contents. Linguistically, I agree with the American judge in Schwimmer versus Air France that in ordinary usage, damage is damage and loss is loss. If therefore the literal construction be legitimate, I would dismiss the appeal. In other words, Monarch would lose. But in my judgment, it is not. It makes commercial sense to apply, if it be possible, the same limits for giving notice of a complaint of partial loss of contents as for one of physical damage. And I'm equally in no doubt that it is the duty of English courts to apply an interpretation which meets the commercial purpose of the convention. And then he goes on to say, it is because I consider it our duty to interpret, if it be possible, Article 26.2 in a way which is consistent with the purpose of the Convention, that I think it is necessary to discuss the intricate questions raised about this Travaux preparatoires and everything else. And he says 3 problems arise. 1. What is the approach to be adopted by British courts to the interpretation of an international convention incorporated by statute into our law? 2. To what aids may our court have recourse in interpreting such conventions, such as can we use Travaux preparatoires? And 3, if our courts may have recourse to Travaux preparatoires to foreign judicial decisions and to the writings of distinguished jurists expert in the field of law covered by the convention, by what criteria are they to select such material and what weight are they to give to it? Our courts will have to develop their jurisprudence in a company with courts from other countries from case to case, is what he says. You know, we do all need to work together. And he makes some very good points in his conclusion. He says, I now come to consider what aids our courts may have recourse to in interpreting an international convention. Once it is part of our law, its international character of an international convention must be respected. The point made by Lord Macmillan in the Stagline case is to be borne in mind. Rules contained in the international convention are the outcome of an international conference. If, as in the present case, they operate within the field of private law, they will come under the consideration of foreign courts. And uniformity is a purpose to be served by most international conventions, and we know that unification of the rules relating to international carriage is the object of the Warsaw Convention. So he says, you know, it'll be absurd if you have a convention which is trying to unify the different laws in different countries, and you then have judges who go and interpret all those that convention all in their own way, without paying attention to what the other judges say. So it makes sense to follow what other judges say as well. It follows that our judges should be able to have recourse to the same aids to interpretation as their brother judges in the other contracting states. The mischief of any other view is illustrated in the instant case. To deny them this assistance would be a damaging blow to the unification of the rules which was the object of signing and the enactment of this convention. Moreover, the ability of our judges to fulfill the purpose of enactment would be restricted, and the persuasive authority of their judgments in the jurisdictions of other contracting states would be diminished. And what he says here is, you know, common interpretation not only means that we look at their statements and their arguments, but they will also look at ours. But if we start by saying we do not believe in common interpretation and we will simply follow what our law says in the way that we interpret our law, you know, then you can't expect other countries to listen to what you're saying either, right? Because you're not open for common interpretation. And he then ends with saying, you know, Curjay at first instance and Geoffrey Lane in the Court of Appeal, so these were the two previous judgment decisions, thought it was unnecessary to have recourse to any aids to interpretation. I agree with them in thinking that the court must look at the terms of the convention first, as enacted by Parliament. But if there be ambiguity or doubt, or if a literal construction appears to conflict with the purpose of the convention, the court must then, in my judgment, have recourse to aids as are admissible and appear to it to not only be relevant, but helpful. Right? Mere marginal relevance will not suffice. The aid must have weight as well. And what he says here is, when we come back to anecdotal evidence and stuff like that, you can't have something, you can't try to argue a point and then grab some text from somewhere which vaguely resembles something along the lines that you try to argue, especially as long as you don't look at the context in which that was said, and then use that as supporting evidence, right? That's useless. So the judge goes on and says, a great deal of relevant material will fail to meet these criteria. Working papers of delegates to the conference or memoranda submitted by delegates for consideration by the conference, though relevant, will seldom be helpful. But an agreed conference minute of the understanding on the basis of which the draft of an article of the convention was accepted may well be of great value. And when he says agreed, he means agreed by everyone then, right? Or at least by the majority, depending on how the convention got adopted. The same considerations apply, and now we come to the common interpretation by courts. The same consideration apply to international case law and writing of jurists. The decision of a Supreme Court or the opinion of a court of cassation will carry great weight. The decision of an inferior court will not ordinarily do so. The eminence and the experience and the reputation of a jurist will be of importance in determining whether, and if so, to what extent the court should rely on his opinion. And this is basically what Fothergill says. It says, of course there should be common interpretation, but you can't just blindly follow everything. You must look at, when you look at a court, you must look at what level the court was. You must look at whether all cases are published or just some. You must look at when it's a jurist, is it his field of specialization or her field of specialization? Are they accomplished or are they new? All those kind of things. And also when you look at conference minutes, you need to understand, am I looking at something anecdotal or am I looking at something that was adopted by the whole conference? All in all, I started reading this case thinking, nah, it doesn't really say that much about common interpretation, but the more one looks at it and the more one considers what has been said, one can understand why it has grown to be the English standard reference for common interpretation in treaties, as even used by the Indian court in the Concentrics case that we've referred to before, and that is also used in Travaux when talking about the common interpretation of treaties. I hope you enjoyed this case. Next time it will be more of a straightforward international or transfer pricing case, but once in a while we need to dive a little bit deeper. Bye for now.